that the Constitutional Court order that he be arrested by Wednesday should be stayed or delayed. That's because he's applying to the Constitutional Court to rescind its earlier judgment that he's guilty of contempt of court for defying that earlier Constitutional Court ruling that he must testify at the Zondo Commission. Well, the Zondo Commission itself is one of the parties in the case. The former president, of course, is a party. Another party, which is admitted at the very beginning of this as a friend of the court, is the Helen Suzman Foundation. Anton Van Dalsen is a legal counsel at the Helen Suzman Foundation. Anton, good afternoon to you. Are you also going to be lodging an argument with the court? Are you also going to be arguing in this application tomorrow?
Yes, we have submitted papers with a view to the proceedings tomorrow. Very briefly, the position that the Helen Suzman Foundation is taking is that in respect of the request by the applicant on behalf of Mr. Zuma to set aside the order by the Constitutional Court, there's a very big problem with that, and there's a big problem with the second part of the application, which is the rescission aimed at the Constitutional Court. In the first case, the request to the Pietermaritzburg High Court to set aside the order, the main problem there is that lower courts cannot overturn verdicts or findings of higher courts. Otherwise, if that weren't the case, it would lead to judicial chaos. So he's effectively asking a lower court to overturn a Constitutional Court judgment, which, from the way we look at things, just doesn't work. And the second point is the rescission, which he mentions in his papers, which is aimed at the Constitutional Court. Now, in terms of the Uniform Rules of Court, there are very limited grounds for such a rescission. And to cut a long story short, and to put it in plain language, it's really limited to cases where there is an obvious glaring mistake. And we're not talking about finer points of law here. So there again, he has a huge problem, and we don't think that that is justifiable to proceed to court on that basis.
Okay, I mean, some of this is technical, some of this is about which court could hear the application, which could not. For you, the correct outcome then would be for the judge tomorrow, I presume, in the Pietermaritzburg High Court, to simply dismiss this out of hand? Well,
from our point of view, I don't think the judge has a choice. The judge would dismiss it, as you say, on the basis of this is an order of the Constitutional Court. He can't overturn or suspend or do anything to an order of the Constitutional Court.
So that would mean then, if you're correct, that the former president should be arrested on Wednesday?
Well, in terms of the order made by the Constitutional Court, that's correct. And yes?
Go on.
If the order is very clear from the Constitutional Court, giving instructions to the Minister of Police, and if anything needs to be changed there, the Minister of Police must go and ask the Constitutional Court what he must do.
Okay, so there's also the Constitutional Court hearing next week. You'll obviously be a party to that. What kind of argument are you expecting to make there? This is the application by Zuma, by the former president, to have the earlier Constitutional Court order rescinded.
Well, as I mentioned, the rules of court dealing with rescission, it's very limited, the grounds that one can ask for rescission. And maybe just in plain language, there are three points which the Uniform Rules of Court mention. And one is if an order is given in the absence of one of the parties. But obviously, if a party chooses not to be part of the proceedings, that doesn't count. And that is the relevance here. And the other ground, major ground, is really for very obvious glaring mistakes. And we're not talking interpretation of laws and things, but to set aside or suspend a judgment where it's very clear that there was something glaringly wrong in the text of the order. So that is, it causes all kinds of problems for Mr. Zuma as the applicant. So we do not see the grounds as being in order to approach the Constitutional Court. We do not see that as being that there is any real chance of it being successful.
You'll have seen the situation, Anton, developing in Nkandla, and we realize that this is about the law and must be primarily about the law, but there is the reality on the ground. Are you worried about some kind of negative outcome there?
I think one of the major things is it's very difficult to judge from what one sees on television about a mob outside Nkandla and to try and make sense of how deep any kind of disquiet goes, or whether these are just a few disgruntled local people. It's very difficult to try and make sense of that. But then you have the basic thing, and that is the rule of law. And if the Constitutional Court has come out with a judgment which very clearly sets out the law, then the principle is that has to be accepted. And if there's unhappiness about this, then there must be unhappiness. But and I think this is something that is in the hands of the government. The government must make it very clear that, guys, this is a judgment of the highest court in the country, and there's nothing that we can do about it, and we must go ahead. I think the sense of accepting the principles of the rule of law, it's something that takes some time, I think. But I think the government needs to underline the importance of the rule of law generally, and to emphasize the importance of sticking to it.
Why, and I'm afraid that maybe I should have started here, but let's just go back a little bit. Why did you apply to be a friend of the court in this case in the first place? And this was where the Zondo Commission asked the former president to testify. He refused. They went to court. He was ordered to testify. He refused. And then you joined the court. You applied to be a friend of the court. What was your aim in all of this? How did you get involved in the first place? What outcome did you want?
The aim of our asking to be admitted as a friend of the court was because the Commission of Inquiry went to the Constitutional Court with a very clear request, and that was for Mr. Zuma to be jailed. We went to the Constitutional Court in our application to be admitted as a friend of the court, saying that there are other possibilities, there are other ways of dealing with this. And one of them is to use what one calls a coercive sentence, in other words, a suspended sentence, provided that the necessary action is taken by the accused. In this case, giving evidence to the Commission. And we felt that it would be useful for the Constitutional Court to be presented with a variety of options so that it could make its decision on that basis and not just be confronted with one potential solution. The court took note in its judgment. You will see that the court took note of our proposals and effectively thanked us for putting these alternatives before the court. But the court, as you know, decided to accede to the request of the Commission. But I think, in retrospect, I think it was very useful for the court at least to be able to be aware of the alternatives that it could use.
Anton Van Dalsen at the Helen Suzman Foundation, a legal counsellor there. I do appreciate the time. Thank you very much indeed. Okay, so those are their arguments that they'll be making in court tomorrow. The Zondo Commission as well making arguments around the jurisdiction of the Pietermaritzburg High Court and whether in fact it can hear this application by former President Jacob Zuma to stay the execution of the arrest warrant. A lot can happen in the next 48 hours, some of it in court, some of it outside.